Good afternoon, everyone. I'm William Asai Renchi, a training coordinator at Temple Small Business Development Center. The Temple SBDC helps small businesses start and grow. We do this through our no-cost consulting, webinars, and training programs. We are proud to be part of this nationally accredited network of SBDCs, over 1,000 centers across the US. You have joined us today on this webinar on the topic, avoiding common contact pitfalls, legal landmines in agreements. So a follow-up email will be sent to all attendees within the next 2 business days with today's presentation and materials. However, all attendees have been muted, and we encourage you to post your questions in the Q&A section or the chat. And all questions will be answered by Mark. So now I turn the floor over to Mark. Thank you.
Great, thank you very much. As was stated, I'm Mark Wendaur. I'm an attorney at Offit Kurman. I'm excited to talk to everyone about some common contract pitfalls here. And if I may, William, as I advance this, there we go. Okay. So first, just a little bit about the firm. So Offit Kurman, 280 attorneys. We have 20 offices. It's a national practice. The bulk of our work is focused on privately held companies, much like the individuals here at the presentation today is what I would assume. The we offer a broad range of services. So really, my focus is on the corporate transactional, real estate transactional, really outside general counsel service of these companies. But we have a wide range of attorneys that do everything from litigation to employment law to family law, estate planning, every single thing that entrepreneurs often end up needing. So just briefly, you can see there, most of my work outside general counsel to at least privately held companies. Like I said, I suspect that's who most of the attendees are here today. What we're going to cover. So to really understand the common contract pitfalls, we need to know a little bit about what a contract is. We're going to explore why these informal agreements can fall apart. We're going to understand what the key contract clauses are that we're getting into, that we're experiencing issues with. And let me see if I can just briefly adjust the layout here. So I'm here. That way I'm not in the screen at all. I'm not cutting off any info. So, we'll understand the real business risks associated with these clauses that we're going to take a look at. And there's one case in particular I'm going to highlight just to kind of demonstrate, the issues that exist when these disputes come about. I'm going to show you some sample clauses, and then we'll do a Q&A. And at the end of this, you'll be able to save this presentation for yourself, so you can refer back to it if you have a contract issue you're trying to work through. But of course, every contract issue is unique. It's hard to know all the facts surrounding it. As you'll be able to tell throughout this, some of these issues can be rather fact intensive analysis to see if there's, what the contract is, what the rights are of each party. So, the typical legal disclaimer. Every fact pattern is different, right? So, let me see. So why do informal agreements backfire? So, oftentimes where we're thinking, as small business owners, hey, it's a handshake deal. I gave you $500 to perform this service, or we had it outlined in an email, and we understood that this is what everyone was going to say. But there's only so much content you can put into a short email. There's only so much that the human mind remembers once you've completed the handshake and handed over payment. Oftentimes we, can forget, or there might be gaps that weren't fully discussed. So we have these missing terms that can lead to disputes about what the responsibilities were, what the deadlines were, what the quality of the work being performed was supposed to be. So oftentimes, disputes are born from these type of missing terms and issues. You also see, as a business grows, the needs change, or maybe team members change. So you have, a loss of institutional knowledge. No one remembers what the actual terms were of that handshake deal, or no one knows where to find that email that had a bullet outline of what was supposed to be done. Um, so again, this is really why the formal contract is necessary. Um, so really, what makes up a contract? So the basic nut, the basic bolts of a contract are offer, acceptance, consideration. I'm offering to do something for you. You're accepting that offer, and there is some type of consideration paid. Now, each of those comes in a wide range of different you know, different classifications. An offer can be in the form of many different things. Acceptance can be in the form of many different things. It can be silence, it can be action, it could be partial action. And similarly, consideration can be a lot of different things. It can be money, it can be services, it can be, personal property. It can be anything of perceived value, pretty much. So when you have a dispute and the courts need to step in, the court's going to say, well, what was the agreement? What do you have in writing? What, documents am I supposed to look at to make this determination? In the absence of a writing, they may look at past practices and try to understand what the agreement was between the parties. But now you're getting into a dangerous and expensive area because um, everyone's interpretation of past practices may be different. The judge and the court, and if you reach a jury, everyone is going to interpret actions differently than the people who were on the ground performing the services engaged in the daily business. Now, there is, oftentimes if you're looking at contract law online, or if you're, using ChatGPT or AI, statute of frauds pops up. Statute of frauds is a very um, long-standing body of law that says certain agreements must be in writing, um, or they're not binding. Similarly, if they are not in writing, they can still be enforceable. So if a contract cannot be performed within 1 year, it it absolutely must be in writing. So if you're, think of someone's agreeing to perform services for an 18-month period on a monthly recurring basis, that has to be in writing. It's that period of time. It's tied to the underlying policy of it is it's tied to the human brain. If it's longer than a year, we very well could start forgetting about it. The court has to identify some type of benchmark to identify, okay, this is the cutoff, a bright line rule. So that's where the 1 year really comes from. If you're dealing with real estate is extremely important. It always requires something in writing. Um, again, with all of this, there are some exceptions. If money was changed hands, something occurred on the property. There are some arguments to be made, but it's not a spot you want to be in. You do not want to be making those arguments because everything gets extremely expensive once that argument starts to occur. Um, you know, Similarly, if you're agreeing to pay somebody else's debt, if you're agreeing to step in and pay their debt, and then any contract for the sale of goods of $500 or more. Anything under $500, okay, that's there's a threshold there, right? It's not a $50,000 contract, which should, has such importance. It should be in writing. If it's something under $500, the UCC, which is a body of law, says that, a handshake can be good enough. But again, those are low stakes in the grand scheme of things. Um, you know, $500 compared to many of the agreements that small businesses enter into, that can be, the risk exposure is limited. So, in the absence of these agreements, what are the most common issues that are litigated? So, was there offer and acceptance? Did I accept what you were offering me? Um, you know, were we still discussing what the terms of the actual services to be delivered were? Or let's say you're in manufacturing and you are obtaining materials from a supplier. We're still discussing what the quality of those materials is supposed to be. The acceptance, how did I accept it? Was it silence? Was it, you know, some type of cryptic email or response that you're taking as acceptance? All of this stuff exists. These are often common disputes. What were the key terms? So when were you supposed to deliver the items by? When was I supposed to perform the services? Um, what was the amount to be paid? Was it going to be paid on a payment plan? Um, of course, what are the prior dealings? Is that going to influence the interpretation of a contract? Because you can have a well-worded contract, but there still may be some aspect of it that isn't clear just because of the parties' past dealings. You have the agreement says one thing, but we have 3 years of history where the parties have deviated slightly from that. And now, if someone is trying to call fault and say, hey, the plain letter of the law, the plain letter of our contract says this, and you are now operating in a way that doesn't align with the strict letter of our agreement. Well, if we have 3 years of evidence showing that the parties did something different, you know, you're going to be able to lean on that some. Let's say, the contract falls apart. What are the damages? Let's say I did not deliver the product on the date I was supposed to deliver it. Are there damages that result from that? Let's think of construction for an example. Let's say we're doing, some type of civil construction. I'm supposed to deliver, an underground some underground piping to your location that you're going to install, and then you're going to pave over top of that as part of a utility construction project. Well, because I delivered that late, now the contractor that was there to provide the paving is backed up, and there may be overages incurred as a result of that. Because they're on standby for 2 additional days. They're losing money. That money is most likely going to be passed on to somebody. If I'm the one delivering the product late and held up the progress, who is responsible for that? A well-drafted contract very well may say I'm the one responsible for that. Um, you know, we have the case I grabbed to show how these disputes involves emojis and casual language. How can these things end up binding individuals? And then, of course, does the statute of frauds apply? This is not an exhaustive list. There are a wide variety of arguments that exist for and against enforcement of agreements. Contracts are often litigated. Even fairly drafted contracts can be litigated, but it's a minimum. When you're engaged in business, it's a minimum to have some type of agreement reduced to writing that you can always point to and say, hey, that's what I thought we had agreed to. So the case example, it's a Canadian case, but I think it really captures some of today's business world, and it's Canadian only because we haven't had one in the US yet. But it involved a farmer and some suppliers negotiating the purchase of, I think it was flax seed, and they were doing it via text message, and the one replied with the thumbs up emoji. Uh, One party said that was acceptance. Therefore, a legally binding agreement has been formed, and you owe me money for my delivery of that. Now, um, why it matters. There's no clear agreements. They need to reconstruct what that intent was from prior texts, emojis, and conduct. That's much more difficult than looking at an agreement and understanding what it means. You're talking about putting someone on a stand, giving testimony, saying, this is how we did stuff in the past. Here are all the text messages I used. This is how we made deliveries and transacted business in the past, versus, an argument in court saying, here's the agreement. Here's the provision that says acceptance. It must be delivered within 24 hours of making the offer. If it's not accepted within 24 hours, it's deemed rejected. That's a much easier position to be in rather than, you know, parading numerous witnesses in and presenting, you know, 3 years of history of text messages. So again, an emoji, extremely ambiguous. So what the defendant, the def the supplier sued the farmer saying, you agreed to buy this flax seed and you replied with a thumbs up emoji and you agreed to it. I delivered it. Now you owe me. The farmer is saying, no, I didn't agree to anything. Um, as you can see here, the defendant's attorney was saying he was just acknowledging that he had received the offer. If a court starts accepting emojis, how are you going to be able to interpret that in the future? So, uh, allowing emojis would open up the floodgates to allow all sorts of cases coming forward asking for interpretations as to what various different emojis mean. I mean, it seems ridiculous, but it happened. You know, what's a fist bump mean? What's a handshake mean? What's a thumbs up mean? The court went and looked and said, you know what? In this case, based on the past behavior, it was an acceptance. There was a history of giving thumbs up emojis in response to proposed contracts, and thumbs up was acceptable. You know, they look at what a reasonable bystander would say in this scenario, and there was a meeting of the minds. And I think the ultimate liability was somewhere around $75,000 over, um, you know, what the delivery of this flaxseed was. Not to mention the legal fees spent arguing over this. You know, let's say, I mean, couldn't have been less than 20 or $30,000. At some point, it becomes uneconomical to argue about this stuff. They didn't spend 90,000, you know, to prevent paying 75,000. But by the time you factor in an additional 20 or $30,000 in legal fees, the time spent arguing over this, the hurt relationship with the supplier and between the farmer, and now on top of it, the farmer also owes $75,000 because the court is finding that agreement exists. Again, becomes expensive. A clear agreement would have saved legal fees and the dispute over whether or not the purchase price was due. So, um, moving from, you know, kind of the example of why uh, contracts are important, we're going to look at, you know, the actual what the actual terms are in an agreement. So, you know, a lot of you here are most likely small business owners, entrepreneurs looking to, you know, you're engaging in some type of commercial contract. Um, it is important to understand what the words mean and, you know, how do you approach these. So the indemnification clause is a significant clause within the agreements. And this really relates back to that example I was just saying a moment ago, where a what if construction materials are delivered late, causing a delay? Who is responsible for that payment? So really, this protects your business from losses caused by someone else. It applies to third-party claims as well, and it'll also define who controls the defense and settlement. You know, poor drafting of this clause shifts huge unexpected costs to your business. You know, we talk about third-party claims. Uh, you know, we'll just continue with the construction site example. Let's say I was delivering, um, some piping to be used in a utility line project. The piping was defective. It caused a leak and damages in the form of, you know, it washed out new roadway, it flooded a person's house. Those victims of the flooding caused by that defective piping then sue the construction company or sue the municipality or sue whoever they think might be responsible. Well, whoever that defendant is going to look around and say, who the heck delivered the piping? It's their piping that was defective. They should be covering these losses. And that's where the third party claims come in. So, in that scenario, you have oftentimes, you know, in the context of construction, the end, you know, installer or the general contractor has language that says, you know, supplier will indemnify me against any losses suffered by due to, you know, defect in workmanship or product or something along those lines. So if you the actual language that you'll see here, you know, this is an indemnification clause. You know, you say each party shall indemnify, defend, and hold harmless the other party from any losses, damages, liabilities, costs, and expenses, including attorney's fees, arising out of. And then, you know, this is the point where you get to outline what type of claims that indemnifying party is supposed to cover you for. So breach of the agreement, sure, that makes sense. You know, okay, I'm supposed to deliver these materials. I never delivered them. You were forced to go somewhere else and you know secure those materials. You did so at a loss because you had to priority order them, so you didn't suffer other losses. Well, the indemnification clause could then be pointed to and say, hey, because you were late on delivering that, I had to go somewhere else and get the supplies. You owe me the difference in what that contract cost me. Um, so it isn't always just third-party claims. It can really be a claim just amongst them stemming from a breach of the agreement. You also have this negligence and willful misconduct comes up in a lot of agreements. Whether or not someone is negligent, you know, that's an analysis. If someone basically, I mean, everyone understands, generally what negligence is, right? Like if someone has engaged in some type of negligent behavior that suffered a loss because of that behavior, someone is goofing around, acting, you know, in a way that um, is not reasonable on a site or reasonable within the conduct of the parties, it may give rise to a negligence claim. Same with, willful misconduct. If someone did something to destroy property on purpose, you know, that kicks in indemnification clauses. That becomes an issue that someone can lean on and say, hey, you're responsible for this loss I suffered under the indemnification clause. Then, of course, the third party claim we discuss, personal injury, property damage, um, violation of law, you'll see that pop up more so, and we kind of get into it here in a second. Environmental claims, let's say a violation of law, there was a regulation that required the transfer of some materials to be regulated and registered, and it was not regulated and registered. And as a result, one party suffered, $10,000 in fines. Well, it's very possible that that would give rise to an indemnification claim. And then, the last sentence here, uh, defend the claim with counsel are reasonably acceptable. Oftentimes, these are negotiated a few different ways. It often says, hey, you're responsible for hiring an attorney and paying all the legal fees and, handling this. We're going to sit back and make sure it gets done correctly. So, environmental indemnification, this often comes up if there's, real estate, manufacturing, logistics. As I mentioned, if something was transported and it wasn't properly registered, regulatory violation, or if contamination comes about for some reason, um, there will be some potential risk here. Um, you know, Similar type of clause, except it's really just saying that the indemnification is for fees arising from environmental conditions, either existing or from a violation of law. And oftentimes, environmental issues can have significant financial consequences. So it may have this carve out, as you see here, is not subject to any liability cap unless explicitly stated. Oftentimes, an environmental issue can be so expensive that they completely carve it right out of any damages cap, which we'll get into here in a moment. So limitation of liability, this gets into the damages cap scenario. You know, if you're entering into an agreement, for $10,000 from a supplier, you want to know what your risk is. You're not willing to accept $50,000 of risk if it's a $10,000 contract. There has to be some boundary. You're not just, stepping into this to say, you know, I have open-ended liability from now forever. Um, and because you entered into a $10,000 contract, somehow you end up liable for $150,000. That would kill a business in many situations. So there's often limitation of liability clauses that are built into these agreements. That way you understand what your risk is. Oftentimes the limitations are limited to, what's the total consideration being paid under the agreement? In the context of a $10,000 agreement, you'd say my total risk exposure is $10,000, or some other amount expressly identified. So you want clear rights and remedies, in the limitation side and in your agreement. If something happens, what damages are recoverable? An injunction says, an injunction is the prohibition by a court of a party engaging in certain activities. So an injunction often comes up in a non-disclosure agreement. I've given you proprietary information about my company. You've now threatened to share that with everyone if I don't pay you some amount of money because you're upset. I can go to the court and get an injunction saying, party B is expressly prohibited from disclosing any of that information. In the extent that information is disclosed, the court steps in and assesses fines and penalties, and it often gives way to other additional damages. So the types of damages that can stem from contracts: consequential, incidental, special, exemplary, and punitive. Consequential, again, back to the construction site. Let's say a party delivers supplies late. As a consequence of that late delivery, I had to keep additional workforce on site for 2 additional days. That is a consequential damage. The amount incurred as a result of keeping additional workers on site for 2 additional days is a consequential damage. Incidental damage could say, you know, you dumped it, you were supposed to deliver the supplies, um, uh, and you failed to pay certain, you failed to pay certain sales tax or something like that, and there's an incident. As an incident to that, I've incurred these incidental damages. It's hard to use in the construction context. The primary ones you're going to see are consequential damages. Incidental, is not as prevalent. You'll also see special and punitive damages. So special and punitive often go hand in hand. Um, a punitive damage is usually something provided by statute. So, for example, Pennsylvania's consumer protection law says if you engage in activity that violates the unfair trade practices and consumer protection law of Pennsylvania, you are subject to punitive damages in the amount of treble damages, which is 3 times the recovery. So let's say you engaged in behavior. So the exact specifics of the consumer protection law often say, you engaged in fraudulent behavior with respect to a consumer. Let's say you defrauded a consumer of $10,000. They file suit under that unfair trade practices law. You would not just be responsible for the 10, well, not you, but the bad actor would not be responsible for the $10,000 that was the subject of the fraud. It would be responsible for $30,000, the treble damages, and that's provided for under statute. And that's typically where you see special and punitive damages come in. They're not really born from case law; they're born from statute and legislative law. That the lawmakers, if you're in Pennsylvania and Harrisburg, or in New Jersey, your legislators there creating statutes, they usually often outline when a punitive damage is recoverable. So, again, this is a sample clause. You really want to identify again what type of damages may or may not be recoverable. Um, you'd want to say direct damages and actual out-of-pocket losses are recoverable. The reason you don't want things to be too, spread. Okay, look, because I delivered the supplies to the construction site late, that caused you to keep additional workers on site for 2 days. Because those additional workers were on site for 2 days, that company also wasn't able to perform, a job 3 towns over. We're getting too far away. The nexus has to be somewhat related to the issue. It can't be too speculative. It can't be too distant. So direct out-of-pocket losses, you want to define, exactly what that realm of losses can be. Let's see. Excluded damages. Similarly, if you don't, oftentimes in types of manufacturing agreements where a company is manufacturing a product for, you know, a supplier or somebody who's going to use that product in another, you know, larger product or sequence of products, will often limit consequential, incidental, special, exemplary, or punitive damages because you don't want, we had a dispute, a number of years ago. It was an oil and gas dispute. Someone brought a piece of machinery on site. The claim was the machinery was defective, and they said they lost, 3 weeks of production at that well site because the machinery was defective. And not only do we need a replacement piece of machinery, we need, all of that lost production as a consequence of that machinery being defective. That could be significant. That could be a significant damages event. And that's why language like this is important because you need to have an understanding of what your exposure actually is. So in that scenario, if you say, there are no consequential damages, you're not responsible for issues like that. Um, you also have things that are absolutely not limited or should not be limited liability. Fraud, gross negligence, willful misconduct, confidentiality violations, IP infringement. If someone takes your intellectual property And, shares it. That one's a little more difficult to put a value on, sort of, once the cat's out of the bag. The IP has to be extremely, you know, valuable um, for this to really kick in. Oftentimes, if you're a tech company, this would be relevant. But oftentimes you see it in gross negligence or willful misconduct. If you have someone on site that breaks a bunch of stuff on purpose, that's, you know, most likely, depending on the terms of your agreement, that's going to be excluded from the liability cap. So here you go, same thing. You have these carve outs. So limited liability limitations and exclusions do not apply to claims arising from fraud, gross negligence, willful misconduct, breach of confidentiality. So that takes it out of any damages cap that may exist in the agreement. Assignments come up often if you're engaged in some type of M&A activity, or you're selling assets, or even in estate planning. The purpose for them makes sense. I'm agreeing to do business with you. I do not want you to then turn around and assign this to someone I don't know, that I have not vetted, I have not qualified, to work with. So anti-assignment clauses make sense in the context of a reorganization or estate planning. Maybe you're doing something, you're reorganizing your corporate structure to have a location. Let's say you're a restaurant, you're operating multiple locations under one entity. For liability reasons, you want to make this into three entities operating distinct at each location. You want to reorganize and assign the agreements specific to each of those locations to your new, three entities. There might be a clause that says you cannot assign such an agreement without the consent of the other party. So in that scenario, it's having an effect that it was not designed to protect against, but maybe that other party has a reason for not consenting to that agreement. Maybe they just need to give consent. Maybe they will not withhold consent without, good reason. Again, words matter. You got to see what it says and negotiate it if you think you want to preserve some of those rights in the future. Also, there's a note, some agreements treat ownership changes as breaches. If you're looking at an assignment clause and it says a change of ownership shall be deemed an assignment, that means, look, if uh, even though the entity may continue to exist, but the owner has been acquired by somebody, the stock in that company has been acquired by somebody else, that would trigger an assignment clause, even though it technically has not been assigned. So, assignment clauses usually look something along these lines. So, neither party may assign this agreement without written consent. Written consent may not be unreasonably withheld. Assigned to an affiliate or in connection with the sale of substantially all assets. Again, these are negotiated. They're negotiated a lot, especially in resident commercial lease agreements. If you are entering into commercial lease agreements and you think you may engage in some type of M&A activity or reorganization activity, take a close look at that. It might have implications in those plans. So, again, payment terms, protecting cash flow. You're performing a service, you're delivering a good. What is supposed to be in that agreement regarding payment terms? So, revenue is critical to business. You cannot have, if you are on, net 30 or net 60, and someone is consistently paying late, 90, 120, that has cash flow issues for you. You need to, and many times have late fees that create accountability. You need to understand what triggers payment. Is it delivery of part of the materials or delivery of all of the materials? Um, the, you know, what if they do not accept it? Are they still required to make payment and pursue some type of other dispute remedy under the agreement? Um, and similarly, obligations to perform should also be tied to receipt of payment. So again, real world example. We had a logistics company. They were providing shipping fulfillment services. The uh, the other party was consistently late on paying their invoices, 60, 90 days. And they said, look, we have to stop this. We're running into, it's creating cash flow issues for us. What do we do? Well, their agreement said, a default and cessation of, you know, performing the responsibilities could only occur after 30 days notice. Well, now you're not getting payment for 60 days. Now you send a notice. You can't do anything. You have to keep performing services for 30 days. You oftentimes want, look, an event of default can come about, which we're going to get into. But if it's an event of default regarding payment, you want to be able to shut that off immediately in most cases. Now, obviously, if you're the other party, in that scenario, you might want to negotiate, that they can't shut it off immediately. But these are all things to consider, and that's why these are unique to your business. You need to understand what makes the most sense for you. So, you know, payment terms, provider shall invoice monthly, shall pay undisputed amounts within 30 days. Um, Late payments accrue interest. Provider may suspend services upon 5 days written notice. That's a pretty good payment term in my view, because it's also identifying undisputed amounts. Sometimes you'll have customers try to say, well, hey, I'm disputing 5% of this invoice. I'm not going to pay the invoice until that's done. What about the other 95% that you agree with? So, a word simply like undisputed amounts, that has a big effect on what the party's rights or obligations may be. Um, Similarly, to when the payment um, is required. Did the work meet expectations? Um, you know, is there a dispute over the quality? Was there an inspection period that then deemed it accepted? You don't want also to have a party just request endless reworks of a product that you've delivered. Um, but it also, the parties need an escape hatch for those payment obligations if what's delivered is completely unusable. I should not be obligated to pay you if, you know, you represented to me that you could deliver a product fit for my needs, and what you've delivered is completely unusable. Um, I shouldn't have to pay you and then fight to get my money back. So, again, that's acceptance. So, you know, 10 days to inspect after delivery. This is often seen, if it's delivering materials or supplies or some type of special purpose manufactured item, you're going to have time to inspect and make sure it's fit for the purpose you acquired it for, you bought it for. Um, of course, again, silence can be acceptance if no notice or objection is delivered in that period. It's deemed accepted. So, and that gets into default and cure periods as well. So let's say, payment is not made, or there was a representation and obligation to deliver a product that could, process X number of widgets in X period of time. And after testing within that, acceptance period, you find it is not able to meet those specifications that were ordered. Send it back. There's a cure period. And by there being a cure period, it doesn't mean, you're returning this piece of manufacturing equipment and they have another year to get it right. No, oftentimes you say, you know, good faith efforts to get it back within 60 days, and if it's not back within 60 days, you can terminate the agreement and you have no longer any responsibility or liability under that agreement. You don't need to pay um, if they cannot get it right, and you also don't need to have an obligation to wait around endlessly for them to try to get it right. But same goes for the other side as well. If you know someone isn't making payment, again, we talked about there needing to be some type of time. Um, you know, if there's an event of default and it is not cured within a period of time, it's good to give that person a period of time to cure it. It's also what the courts want to see. If, there's a bright line, there's a period of time by being built in there, that avoids a scenario. Well, hey, in an email, you said I would have time to fix it. It's been 45 days. I was going to get it right at 60 days, but now you've terminated the agreement. Well, if it was in the agreement that they had 30 days or 45 days, that avoids a scenario where, there was an email saying I had time to fix it. What did that mean? How much time? So again, you want the clear words that matter. Um, so, that's where it comes up here. Fails to cure the breach within 15 days after receiving notice. That's a material breach of the agreement. That often ties into the termination clause. You can terminate an agreement after, an uncured breach has occurred. It's a critical, I made a special note here because it really is a critical aspect of all business agreements. If you are, the supplier or the one that wants the chance to cure it, you really need to make sure you have a chance to cure. If it's a financing agreement and you send a check, or let's say you have a cash flow crunch and you can't get payment out for 5 days, you don't want someone to say immediately, hey, you're late, the agreement's terminated, in a financing context, the full amount is due. You want some wiggle room in there depending on what side of the coin you're on. Same thing, there needs to be finality to what that period is. So you need to clearly outline what the term is. And then, we're talking about just drafting clear contracts, but of course disputes occur. So, dispute resolution. Um, you often see times now, I mean, I'm not real warm to the notion, but they will make good faith efforts to discuss, to confer and discuss and try to work out a resolution, or they'll take it to mediation. To discuss. Mediation isn't binding. Informal discussions are obviously, hey, we're going to, try to get together and hammer this out so everyone's happy. Sometimes it works, sometimes it doesn't. Sometimes a phone call is needed, and that's all. But that gets into the issue of, okay, we couldn't reach an agreement. Now it's arbitration versus court. What is the most beneficial thing to include in your agreement? Arbitration is confidential. It's not a public docket. No one can see that there's a dispute. That's one big benefit of arbitration. People often say cost, speed, and confidentiality. I'm not sure that's always true. I think, you are still litigating the issue in arbitration, just like you are in court. The court oftentimes brings more structure and formality to the dispute. But arbitration, if you look at, the American Arbitration Association, you pull their rules of procedure, you will see they have procedures as well. They have, response timelines. Everything is a little bit, more condensed and can be a little bit more informal, but sometimes that also hurts you because you're not dealing with, you know, a well thought out, well documented issue. You're dealing with something a little more informal, and sometimes that can be hurtful to the dispute if you're trying to get it resolved. So that's often, it's a privacy, in my opinion, is the big issue between arbitration and court. So, this is one of those clauses, where shall meet with informal discussions and try to resolve it. But again, you need, if unresolved after 15 days, I think the most important part about that, if you use it, is to have a timeline. So there's finality to it. And then go through the American Arbitration Association if an agreement cannot be reached. And then, of course, if a judgment is awarded, you have to still enter it within the court before you can execute on it. Let's say someone owed you $50,000. They aren't paying it. They have real estate. They refuse to pay it. So your only option is to then file a judgment in court and try to force the sale of their real estate to make good on that $50,000 that you are owed. There's still a court process involved with that. So you're not completely out of the court process. But, certainly for privacy, if you're trying to just keep what the actual dispute is somewhat confidential, arbitration is the better way to go. And then, of course, there I get into a note here: recovery of attorney's fees and costs. The prevailing party, oftentimes has the right to recover their attorney's fees that they paid out of pocket. Discourages frivolous lawsuits. I'm not going to fight over something, silly. If I am potentially on the hook for not only damages under the agreement, but also the legal fees incurred by the other party. It also encourages quick settlement. If not only are you paying for your attorney, but the other attorney, well, now, you have two attorney meters running. That starts to become concerning, from a financial exposure standpoint. So this is, usually what the sample clause looks like. Um, you know, in any action or proceeding arising out of this agreement, the prevailing party shall be entitled to recover its reasonable attorney's fees. All right, let's see here. So we're getting closer to the end here. Choice of law and venue. If you've ever been on a cruise, I believe the cruise famously says that all disputes shall be handled in Florida. So if you're buying a cruise out of, Pennsylvania, you can only ever file a dispute and appear in a Florida court. That's inconvenient, but that's what you agreed to in the document. I think Disney is probably along a similar lines. There was a dispute a few years ago where someone waived you know, I think, you know, gross bodily injury on a Disney cruise ship because they had agreed to the Disney Plus terms of service that waived filing suit and had agreed to arbitration instead of filing, an actual lawsuit in courts. So, I mean, those are extreme examples, but it's an example of choice of law and venue. What law is going to apply here? Where is this dispute going to happen, especially if the individuals are from different states? So, it often expressly says governed by the laws of the state or commonwealth of. Conflict of law is this principle where, let's say Pennsylvania law says one thing and New Jersey law says something different. Pennsylvania governs. There's no, regard for the conflict of law that may exist. And then, of course, the venue is where it shall be, you know, where the action shall be filed, where the parties shall appear. Um, Forum nonconvenience is a legal term of art that basically says, you know, absent that, you have the right to say, hey, you're trying to drag me to Florida. That's extremely inconvenient because I'm in Pennsylvania and you have an office right down the street from me. So why do I have to go to Florida? With that last sentence, you're waiving that argument. Um, Force majeure, this was a big one, in COVID, but also cyber attacks. Let's say something happens that completely shuts down your system and it prevents you from delivering, from either getting workers on site or delivering goods as you had, agreed to. There was an article I authored last year on a cyber attack. There was a logistics company. During Christmas, they suffered a ransomware attack, shut down all of their systems. They could not send out, it was skiing equipment during the ransomware. It was Christmas time. So all of these damages stem from that because everyone, of course, said, I want to buy new skis and ski equipment for my family members. Well, now the logistics company couldn't send them. So they went and bought the stuff, the equipment from some other supplier. You know, force majeure says, hey, I wanted to perform, I couldn't perform. That will excuse um, any breaches in that case, is essentially what the force majeure does. And here's a sample here. Again, we're going to share the slides so you can go through and take a closer look at this stuff. Of course, termination rights as well. It's a big one. This comes up all the time. We have clients who negotiated their own real estate leases for their commercial enterprises. Say, hey, we no longer need this site. We're consolidating. What do we need what do we need to do to terminate this lease on, this site? And the termination, as many folks know, for a lease, you can't just get out of it on 30 days notice. You're in it for the term. Same concept applies to, accounting services, marketing services. So many times these agreements say, hey, it's a 1-year contract. Doesn't matter that you don't need this after month 4. You still need to make payments through the end of the term. So, you want to be mindful again of what side of that you're on. If you want a short termination period, or if you want to lock someone in for a longer term to, if you're the service provider, you want to lock them in for a longer term so you have, guaranteed cash flow for that period of time. And again, here's a sample clause that you can use, to make sure it's drafted. A breach often, allows for immediate termination if not cured. Termination for convenience is that scenario where, hey, I don't need this anymore. I need to terminate because it's financially convenient for me. Oftentimes 30 days notice, 90 days notice, these are things that are bargained and agreed to. Um, Integration clause is saying, look, we have this binding agreement. We said this one time in an email that we were going to do it a different way. Does that become part of the agreement now? The integration is saying, hey, everything that we've agreed to is within the 4 corners of this document. We're not going to look to whatever we've said via text, via email. All this other stuff may be one-off, one-off modifications, but at the end of the day, it doesn't change the actual term of the agreement. That was a one-time thing. The integration clause says everything that's in this document is the document. And that also applies to, if you have a statement of work or something else. So I want to leave 10 minutes for Q&A, but at the end of this, I've included, a red flag contract checklist. So, are there missing or vague business terms? dangerous indemnification language. You can pick this up when you're looking at your next agreement and run through and see if there's anything of concern in the agreement. And then, of course, if there is, I suggest you contact your legal counsel. You can, of course, try ChatGPT. I'm not endorsing that, but it at least helps you understand what it is saying. But there is, of course, a lot of nuance associated with drafting it. So, sort of user beware unless you engage an attorney to help you understand exactly what's going on there. But there are a few slides here. Like I said, pick this up next time you're negotiating an agreement. Run through and see, what red flags exist. What should you be considering when you're doing, when you're doing that negotiation? I'll cover just the general ones really quick. Is it really one-sided? Sometimes that's the only way you're going to do it. If you are, this comes up oftentimes in, utility service providers. If you are, if you run a company that provides maintenance on the electric lines in the winter, you're not going to negotiate an agreement with Pico. And yes, we'll make sure to get a copy of this emailed, but you're not going to negotiate the agreement with Pico. Pico's going to say that is what it is. Um, Heavy use of vague terms, reasonable, as needed, industry standard. There's no real good way to benchmark that without fact-specific analysis. It can become difficult. Um, if it's not in line with what the parties actually operate, if it's not how you're going to actually perform the services under there, make sure it gets changed. Missing signatures, massive red flag, massive issue in litigation. Then, of course, conflicting terms across sections. Again, massive headache if you're trying to understand how the parties are supposed to act when something is not lined up. So, you need clear contracts to prevent those disputes and protect your business. We've outlined the foundational clauses. We're going to share it, take a look, and try to, keep these in mind next time you're doing an agreement. Key agreements, such as your services agreement or your vendor agreements, take a look at them annually, see if your needs change. Just like you take a look at your profit and loss statements, take a look at these agreements, see if they are what you need for the year ahead of you. If it's unclear or if there's heightened risk, in my opinion, there's no reason somebody should be negotiating a $150,000 agreement on their own. You really need some qualified help because that's oftentimes an issue under that agreement can wipe out the business. And that really gets into an ounce of prevention is worth a pound of cure. It's much more expensive to litigate these issues than it is to spend 3 or 4 hours to have an attorney review it and negotiate with the other side. So, questions. I saw a couple questions come up in the chat. Let's see. All right. We had a couple. Yes. Given the advent of AI, what is the most cost-efficient way to go about creating a contract? I mean, loaded question, right? So, I have seen a number of agreements that, from everything from an operating agreement to a letter of intent to a services agreement that has clearly been generated with ChatGPT. I can tell it's been copy and pasted out. It has the formatting. It has those headings. It has those dividers. You can clearly tell where it came from. I think a great exercise is to drop in just to demonstrate, cost efficient versus dangerous. To drop into, ChatGPT an outline of the terms you want, and ask it to generate an agreement, and then run through the red flags list and the terms we just discussed, and see which ones are absent, which ones are included, and how the language lines up. Now, it's not to say it's not helpful. It's most helpful once you have a good, well-drafted agreement to go back in and ask specific questions of ChatGPT, Copilot, Gemini, all these other platforms, and say, what does this mean? How can I redraft this to be more friendly to me? In my, this is what I needed to say. That's, you know, that gets you part way there. Um, but again, there are some real nuance to this. If you make a change in one section, it may create conflict with another section. But my suggestion is to use it as a learning tool, not a drafting tool. Does the SBA provide offer templates or contracts. Um, so I know the SBA has a pretty good resource for kind of discussing what things are. I don't think they have a good, sort of offer agreement. If you're talking about search funds or, buying a business, um, Stanford's entrepreneurship through acquisition website has a really good primer, and it goes through a lot of, um, how do you make an offer? What is an LOI? You can find it, and AI is a great way to explore and better understand what these things are. Okay, what should I consider when making an offer to buy a business if that's what we're, considering? Um, I see provide or offer templates or contracts. Really, look online, see if you can find a sample agreement with reputable companies and see what that agreement looks like. And, that's one good way to get an understanding of what an agree, what the agreement might look like, what perhaps it should include. Um, but I don't think the SBA has a real, good template or contract repository for people to pull from. The range and the amount, can expect to on when creating a contract, and is it better to have a lawyer do it? It really depends on what it is, right? So if it is an agreement for, a used piece of machinery that's $10,000, um, it's used, you're buying it with risk. It's probably not worth a ton of money. It's not worth it to have an attorney draft an agreement for $8,000, and an $8,000 agreement isn't necessary for that. If you are, so, we work with like specialty chemical suppliers, manufacturers sometimes. If you are negotiating a 3-year supply agreement to deliver a specialized chemical um, in that, will be used as an additive for some other um, product you are delivering, it's not uncommon for it to be a $10,000 agreement because, these are 35, 40-page agreements. We're discussing environmental risk, logistics, shipping, um, third-party liability, indemnification, quality of the product. You're representing that. Perhaps it requires special manufacturing tools or chemicals, to do it. But in the bulk of the agreements that small businesses run into, uh, I would say drafting an agreement that you use in general every day should generally run between $2,000 to $5,000, unless you're getting into something more special or if there's higher risk. Again, that's perhaps the best way. How much it's going to cost depends on your risk exposure. If there's a lot of risk, if it's an expensive issue, expect to have a longer document because there's more risk. You need to really protect against it, and that's gonna be a um, more expensive drafting experience with your attorney. But then also once it's drafted, a lot of times these documents are evergreen. I have clients that we drafted documents for 2, 3 years ago. They use it every other week. They drafted it. We went through it once. We have it dialed in. Sometimes, a party asks for an edit. We spend 30 minutes or an hour looking at it, saying, yeah, this is good. No, this is bad. And that's it. It was a one-time drafting. Um, Let me see. What else did we get in here? Let's see. Uh, an entertainment lawyer specifically, for example, a vendor contract with a production studio. It if I wouldn't say you need an entertainment lawyer specifically. A lot of times you have entertainment lawyers negotiating intellectual property rights, name and likeness use. Um, we've done some of that stuff. We have an IP group here at Offit Kurman that does a lot of that. But really, what you're negotiating for what it sounds like, a vendor contract with a production studio, you're negotiating a services agreement. So they will stand up. I'm sorry, you will show up. They're going to help you produce a show, whether or not that's cut and edit, the recording that they've done, maybe they're adding some B-roll to it. Maybe they are packaging up or sharing it somewhere. But that's really a services agreement. An entertainment lawyer really gets into the intellectual property side of it, and when royalties may be involved, and when there may be multiple stakeholders in the outcome of that entertainment piece being created. So, um, it looks like that's it for the questions. It was really great, you know, sharing the lunch hour with you. Um, we do, uh, Corey Hooks, we do have entertainment attorneys. If you want to shoot me an email, I can connect you with one of them. Um, but it's been great sharing the lunch hour with everyone. Um, if you're here, congrats on your entrepreneurial journey. It's a lot of fun. If you need help, feel free to reach out. We're going to share the slides. The recording will be around. Always happy to be a resource. I'm local to Philadelphia, so if anyone wants to, you know, stop by the office for coffee anytime, let me know. But thank you, Temple, for hosting me, and look forward to seeing everyone next time.
All right. Thank you everyone for joining us today. Thank you, Mark, for presenting today too. So guys, a survey for today's presentation has been posted in the chat box. We actually value your feedback, and it's also required by our founders to continue to provide these no-cost webinars. As Mark said, a follow-up email will be sent to our attendees within the next 2 business days with today's materials too. Have a nice day, guys. Thank you all. Bye.
Thanks. Bye. I'll drop my email right here so you guys can have it. All right, great. Thanks, everyone.